This little city has a fairly complicated regulatory program, and so the relationship among the components is, I think, an interesting topic. The most standard issue that we all run into is the relationship between the comprehensive plan and the zoning, and the Hornbook understanding is the comprehensive plan is indeed a plan, and the zoning is the implementing regulation. But we have the complication that the comprehensive plan is referenced in a couple of the zoning review standards, so we have to figure out what that really means, and how that, changes the game on review. So that's obvious big question that's raised there. Mr. Vansel suggested there's some case law on that question. So that's right. So that would be something that you would discuss. I'm just, talking off the top of my head, I don't think it would, the basic principle that the comprehensive plan can't contradict the zoning, I don't think gets changed by that, but it may bring in the comprehensive plan in areas that the zoning doesn't talk about, sort of the silence factor, and it would also potentially bring in the comprehensive plan as, fleshing out the zoning standards. Are the two obvious questions to be thinking about. Another question is the comprehensive plan has different kinds of things in it. It has not only policies, but then it has goals and apparently overriding principles. Are those all of equal regulatory effect? I think that's a question that is worth addressing. We've had a lot of citizen comment that's focused on the overriding principles, so I think we'll need to come to terms with the question of whether those have the same effect as policies or different, and how that all spells out. And I don't know if there's any case law on those questions or not.
I've reviewed that issue before, and I believe there is some case law which we can provide.
Okay. Something we haven't really talked about that comes up a little bit in the more recent testimony, particularly Mr. Peltier's testimony. What, if any, is the regulatory role of the design guidelines? Is there any regulatory effect? And what effect, if any, attaches to the design review board process? I've never really looked into that question at all. I'm not sure to what degree this is all unique to Bainbridge. I think to some degree it probably is. Anyway, that question, I think, probably needs to be talked about. And, on the SEPA level, there's this kind of myth that environmental impacts kind of exist in this very pure factual vacuum, but in fact, the determination of impacts is tied to the regulations. Impacts are to some degree what the regulations say they are. And so that question of how the regulatory framework interacts with the determination of what the environmental impacts of the project are is a question that comes up. And then with respect to that, the comprehensive plan, particularly, there's a lot of talk about whether the terminology relating to economic impact studies has any applicability to this proceeding. That seems to mostly project within an area already zoned commercial. That seems to be the big issue there. There's some interesting questions around the conditional use permit stuff. We touched on some of that. I touched on some of it at the pre-hearing conference. Mr. Machen's testimony also implicated some of that. The basic question, you've got a trigger, the 5,000 square foot trigger, and the question is, does the nature of the trigger somehow define the scope of the review? The expansive view would be the trigger, once it is goes off, the review is the full review of everything that the comprehensive plan policy or the conditional use standards could possibly encompass. The other view would be that the extreme other end would be, well, everything under 5,000 is permitted, therefore the review is limited to only the impacts of the project in excess of 5,000 square feet for any given building. So those are kind of the two bookends of that question, and then there are all sorts of in-between positions that you could take. Also is the 5,000 square foot limit trigger or limitation only applies to the high school 2 zone, but the project in its entirety covers high school 1 and 2 zones. So is the review of the entire project under the CUP standards, or would it be just a portion of the project in the high school 2 zone? Also, this is where Mr. Machen's testimony, I think, was interesting. He looked at the comprehensive plan and said the purpose of this 5,000 square foot limit is to protect a single family type of zone, and therefore it doesn't apply to anything else.